Okay, I think we can make a start. Tēnā katoa, hello everyone. My name is Michał Mott. On behalf of the Law and Economics Association New Zealand, I would like to welcome you to this lunchtime webinar. Our guest today is Sue Barker. She's an expert in charities and charity law in New Zealand. The topic we're going to discuss today is the role of charities sector in New Zealand and the impact of the planned changes of the legal and economic framework that applies to charities. Charities have an important role to play in democratic society. They strengthen communities, they improve social cohesion and deliver social benefits that complement actions by business and government. Charities play a key role in upholding liberal democratic values and promote public debate. LEANZ is a registered charity. In order to thrive, the charities sector needs an appropriate legal and economic framework, and we'll hear from our speaker today what that legal framework should be and whether we're on the right path. Sue Barker is the director of Sue Barker Charities Law, a boutique law firm specializing in charities law and public tax law. She's a director of the Charity Law Association of Australia and New Zealand and a member of the core reference group for the government's review of the Charities Act. In 2019, Sue was awarded the prestigious New Zealand Law Foundation International Research Fellowship, Te Karahipi Rangahau a Taiao, to undertake research into the question, what does a world-leading framework of charities law look like? The report from the fellowship, entitled Focus on Purpose, was released in April 2022, making 70 recommendations for charities law reform in Aotearoa, New Zealand. Sue's presentation will be followed by a Q&A session, and I'd like to invite you to ask questions in the chat. I'll convey them to the speaker. If you prefer to ask questions yourself, there should be an option to raise your hand. I think you have to click on the reactions button and you'll see that option there. And I'll call out your name to ask your question. I should mention that this webinar is being recorded. I will turn off the recording for the Q&A session. On that note, I'll turn over to Sue. Sue, over to you.
Thank you very much, Michelle. Tēnā koutou katoa. Hello, everyone. It is an honour and a pleasure to be here today to speak with you about the Charities Amendment Bill and its impact and risks. I'm just going to try to share my screen, so please bear with me because it appears to take a moment to start.
Yeah, we can see it.
Thank you. Hopefully it will come up shortly. Awesome, thank you. As Michelle said, I am the New Zealand Law Foundation 2019 International Research Fellow, which I'm honoured to say is New Zealand's premier legal research award. So I've had the privilege of being on sabbatical for 2 years, undertaking research into the question of what does a world-leading framework of charities law look like, focusing on New Zealand, but also drawing learnings from 5 comparable jurisdictions: Australia, Canada, England and Wales, Ireland, and the United States. So in order to look at the impact and risks of the Charities Amendment Bill, I'd like to put it into some context. As you may be aware, in 2015, New Zealand, along with all other United Nations member states, adopted the 2030 Agenda for Sustainable Development. At its heart are the 17 Sustainable Development Goals, which are an urgent call for action by all countries to address the great challenges that humanity faces and achieve a better and more sustainable future for people and the planet. Goal 1, ending poverty in all its forms everywhere, is tied with Goal 10, reducing inequality within and among countries. While the last few decades have lifted hundreds of millions of people out of poverty, they have also led to unequal growth, increasing job insecurity, ever more debt, and greater environmental risks. You will be aware that 1% of the world's population now owns more than half, I understand, of the world's wealth, and the gap is widening. A recent report by Oxfam revealed that the richest 1% captured around half of all new wealth during the past decade. This mix has fueled an anti-globalization reaction in many countries, and the widening gap between rich and poor is putting pressure on democracy, not to mention peace and prosperity, Goal 16. Poverty is also a key driver in environmental degradation, Goals 6, 13, 14, and 15. As Dr. Jane Goodall has said, in order to fix the environment, we have to fix poverty. And Goal 13 also recognises that our window to avoid catastrophic climate change is closing rapidly. But perhaps most importantly, Goal 17 recognises that international cooperation is vital to achieving these goals. Earlier this month, the United Nations General Assembly agreed an important resolution encouraging member states and financial institutions to promote and support the work of the social and solidarity economy. The resolution recognises that social entrepreneurship, including cooperatives and social enterprises, can help to alleviate poverty and catalyse social transformation by strengthening the productive capacities of those in vulnerable situations and producing goods and services accessible to them. An economy that is more democratic and more rooted in its territory can play an important role in achieving the SDGs and confronting the challenges that humanity faces. As former UK Prime Minister Gordon Brown has said, there is no route to the future that does not have social enterprise at its centre. A recent report launched by the Business and Sustainable Development Commission also positions the SDGs as a compelling strategy to reverse the trend of rising inequality and unleash innovation, economic growth and development at an unprecedented scale. The report concludes that pursuing sustainable and inclusive business models could unlock economic opportunities worth at least $12 trillion a year and generate up to 380 million jobs, mostly in developing countries. However, we are apparently 23 or 28 trillion short of being able to achieve the SDGs by 2030. Failing to achieve the SDGs will jeopardise the future livability of the planet for everyone and condemn billions of people to misery. The key point is that governments cannot do it all alone. We need to work together. We need to mobilise civil society, government and the private sector to achieve these goals. And in particular, we need to unlock and unleash the potential of civil society. Western literature, and I acknowledge that it is Western literature, often conceptualises society as having three distinct sectors: business, government and civil society, with family occupying the space in between. By civil society, I mean all not-for-profit, non-state, non-partisan, non-violent, self-governing organisations outside of the family in which people come together to pursue shared needs, ideas, interests, values, faith and beliefs, including informal associations without a legal status but with a structure and activities. Civil society may go by a number of other names, such as the third sector, the not-for-profit sector, the for-purpose sector, the tangata whenua community and voluntary sector, the core sector, and others. Arguably, the lack of agreement on a name is a reflection of the diversity of the sector itself and something to be celebrated and embraced. But whatever it might be called, the charitable sector is a subset of it. The charitable sector can be thought of as all entities that are eligible to be registered under the Charities Act 2005. That is, all not-for-profit entities that have purposes that meet the centuries-old definition of being exclusively charitable. Unlike a number of other jurisdictions, charities in New Zealand are not required to register. An unregistered charity can still call itself a charity and seek funds from the public. However, registration is the gateway to a number of privileges. For example, registered charities are able to access certain tax privileges, such as an exemption from income tax, and possibly also donee status, which is a way of encouraging donations by enabling donors to claim a tax credit or a tax deduction for their donation. Charitable registration can also unlock access to corporate discounts and other forms of corporate support, and it can impact on a charity's ability to attract members and volunteers. But most importantly, Many funders will, rightly or wrongly, only fund registered charities. This means that decisions about which charities are able to gain or maintain registration have important implications for which charities are able to obtain funding, which can in turn have life or death consequences for a charity. The charitable sector touches all aspects of our society, including health, education, social housing, poverty reduction, inequality reduction, public interest journalism, sport, protecting the environment, climate change, well-being, and many others. But sadly, the charitable sector is often undervalued or overlooked. It is often viewed in isolation, off to one side, or simply ignored altogether. It can be invisible to policy and lawmakers. Dr. Lester Salomon, one of the world's most influential scholars of not-for-profit organisations, describes the sector as the invisible subcontinent, poorly understood by policymakers and the public at large, encumbered by unnecessary legal limitations, and inadequately utilised as a mechanism for addressing public problems. Why is that? Perhaps it is because traditionally decisions based on measuring value have focused on monetary value. The business sector makes money and is therefore considered important. The charitable sector and the wider civil society in which it sits are motivated by values other than profit, and therefore perhaps their value might have been discounted. But this view doesn't take into account the fact that the charitable sector in New Zealand collectively has some $73 billion of assets under management. Its combined total gross income last year totaled around 23.5 billion New Zealand dollars, representing approximately 6.2% of New Zealand's GDP. The charitable sector also has more than 208,000 volunteers, contributing approximately 1.7 million hours every week, and about the same number of full and part-time employees, representing about 5% of New Zealand's workforce. So the charitable sector is a significant sector, even if we are measuring things in a traditional way. But this government has a stated focus on well-being. The sector's contribution is even more significant when the wider benefits that it confers are taken into account. As noted by the Australian Productivity Commission in 2010, charities and other not-for-profit entities generate important externalities or spillovers that go beyond the direct impacts of their activities. For example, involving families in the local community in the delivery of disability services can generate broader community benefits or spillovers, such as greater understanding and acceptance of all people with disabilities, thereby enhancing social inclusion. Smaller community-based bodies can also play an especially important role in generating community connections and strengthening civil society. As we saw during COVID, the charitable sector provides vital glue that holds society together. Sir Stuart Etherington put it this way, and this quote I think really sums up my view about the charitable sector. He said, "Civil society is essential to building a strong society and economy, and I believe that all of us, regardless of political persuasion, should passionately, explicitly, and unashamedly support people getting involved in their community, coming together in clubs, groups, and societies, starting charities, social enterprises, or community businesses, doing things for the wider public benefit, not simply private gain. We know that a better future is about more than growing the economy. In a famous speech of more than 45 years ago, Robert Kennedy said that GDP does not allow for the health of our children, the quality of their education, or the joy of their play. It measures neither our wisdom nor our learning, neither our compassion nor our devotion to our country. It measures everything, in short, except that which makes life worthwhile." For many, the answer instead lies in civil society. It is charity and volunteering that allow them to find identity, meaning, and purpose, a sense of autonomy, pride, and utility. It is often how we find balance in our lives, pursue our passions, and fight for change. And for society at large, it is often how we build stronger communities, give people a say in what happens to them. It is how we provide services that people depend upon, develop new ways of doing things, and nurture the people who will lead our future. New Zealand has traditionally ranked very highly in terms of levels of social capital and has also prided itself in having a strong culture of volunteering. But our levels of social capital are dropping, as are our numbers of volunteers. Conceptually, one can think of the business sector as comprising private organisations operating for private purposes. The government sector as public organisations operating for public purposes, and the charitable sector as private organisations operating for public purposes. The essence of a charitable purpose is that it must operate for the benefit of the public. And one of the most important features of charities that makes them, and key to what makes them distinctive and valuable, is their independence. Charities enable people to come together in furtherance of a shared purpose, free from the dictates of the median voter or profit-seeking private shareholders. Charities' independence enables them to take risks, experiment, innovate, and reach into communities in ways that governments cannot. Charities are also untethered to electoral cycles, potentially enabling them to address issues on a longer-term basis than governments. The diversity of the charitable sector allows for authentic expressions of pluralism, democratisation, and localism, as people come together to address issues they see arising in their communities, which issues may not even be on the radar of government. Charities' independence underpins their advocacy work, which has been critical in many important societal changes that have been achieved over the centuries, including the abolition of slavery, universal suffrage, anti-smoking laws, and so many others. Charities provide critical balance to the ability of the most economically powerful to dominate and shape policy, thereby providing important protection against the skewing of public policy debates in favour of vested, moneyed interests. Charities are often described as the eyes, ears, and conscience of society, with an important role in holding government to account. In a liberal democracy such as New Zealand, it is critical to protect the independence of charities and the boundary, particularly between civil society and government. Which brings us to the Charities Amendment Bill and the question of whether or to what extent it achieves the imperative of protecting the independence of charities. But to do that, I'd like to look at a little bit of the background, including the terrorist attacks that occurred in the United States on 11 September 2001, or 9/11. Following the attacks, the Financial Action Task Force, or FATF, issued a series of special recommendations focused on terrorist financing. Recommendation 8 urged countries to review the adequacy of their laws relating to not-for-profit organisations, arguing that they are particularly vulnerable to being abused for the financing of terrorism. Although one of the terrorist pilots had apparently been funded through a US not-for-profit organisation, there was in fact no evidence that the not-for-profit sector was in any way more likely to be exploited by terrorists than any other sector. Recommendation 8 controversially changed government's attitude to independent civil society organisations by casting suspicion on the entire not-for-profit sector and providing a rationale for a shift from benign registration regimes to active regulation. Recommendation 8 led to blunt, sector-wide increases in restrictions, which badly damaged the relationship and levels of trust between governments and civil society. Ironically, FATF has since acknowledged the negative effects of Recommendation 8 and revised it. It now reflects the need to protect the legitimate activities of civil society organisations and no longer includes the vulnerable wording. The UN Special Rapporteur has also called on states to improve their cooperation with civil society and embrace not-for-profit organisations as indispensable and integral to the solution in the fight against terrorism. However, the damage was done. Following 9/11, there was a wave of charities legislation around the world, including in New Zealand and countries that we compare ourselves to. Between 2004 and 2010, more than 50 countries enacted restrictions on civil society. There may not be a direct link in all cases. For example, I'm not suggesting that China's charity law of 2016 was a direct response to 9/11, but certainly in the case of New Zealand and also Ireland, it was pressure from the United Nations Security Council following 9/11 that led to specific legislation for charities. In New Zealand, our Charities Act 2005. Reaction to the Arab Spring uprisings set off a second wave of legislative restraints, with more than 70 countries enacting new restrictions from 2012. The overall impact on democracy of these measures has been profoundly negative. FATF's Recommendation 8 spawned a counter-terrorism narrative that led to a decreased tolerance for risk and an explosion of counter-terrorism measures that prioritised security at the expense of democratic norms. The net result has been a proliferation of government regulation and an increasing erosion of fundamental human rights, including crackdowns on dissent and a shrinking space for civil society around the world. At the same time, autocratic states have been working to shift the post-World War II consensus that democracy is the only viable path to prosperity and security, including by attempting to destabilize democracies from within. The overall result is global democratic retreat. The number of democracies backsliding into authoritarianism has doubled in the past decade, to the point that 90% of the world's population, 9 out of 10 people on the planet, are currently living in countries rated as closed, repressed, or obstructed. Even Australia and much of Europe are rated as narrowed. The global order is currently approaching a tipping point in the battle between liberal democracy and the forces of autocracy. And it does not appear to be widely appreciated that the legal framework for charities is one of the front lines in this regard. And if you think about it, if you were an autocratic state wanting to spread authoritarianism, where would you start? You'd start with civil society, as we have seen, for example, in Russia and Hong Kong. Nearly half of the restrictive measures enacted over the last 20 years are framework legislation, targeting aspects of the incorporation, registration, and ongoing operations of civil society organisations. Such authoritarian tendencies are not restricted to authoritarian states and can be observed even in established liberal democracies, such as New Zealand. Globally, charities legislation is increasingly being used as a tool for suppression of not-for-profit advocacy. Civil society is operating in an increasingly hostile environment. 22 years on from 9/11, it is timely to ask whether all of this regulation is working. New Zealand now has arguably the most restrictive framework for charities of all comparable jurisdictions. We also have, as far as I can tell, the most comprehensive set of transparency and accountability disclosure requirements for charities in the world. Yet, after many years and millions of dollars of regulation, public trust and confidence in charities has declined. I know that these surveys have their limitations, and there are many other factors at play, but the point, in my view, is that New Zealand is currently over-regulating charities, and this is undermining their independence. This, in turn, is causing people, particularly young people, to turn away from charities and choose other modes of social action. Because this is a law and economics webinar, I'd like to touch on a point of economic theory. By way of disclaimer, I'm not an economist, but I do think that multidisciplinary expertise is critical in this area. The various disciplines need to find a way to talk with each other about these issues, because otherwise these issues risk falling through the gaps. I'd like to talk about the tax expenditure analysis. In its 2018 and 2019 reports, the Tax Working Group conceptualized the tax privileges for charities as concessions and concluded that the charitable sector's use of what would otherwise be tax revenue should be periodically reviewed to verify that intended social outcomes are being achieved. These statements reflect a tax expenditure analysis, which appears to be underlying decision-making in this area. The tax expenditure analysis can be traced back to the work of Harvard law professor Stanley Surrey in the 60s and 70s. It takes the tax privileges for charities and conceptualizes them as a subsidy, more or less equivalent to a direct grant. It then recasts the revenue said to be foregone from that subsidy as a direct tax expenditure by government. And you will see some of the tax privileges for charities listed in Treasury's annual tax expenditure statements and ascribed a value. The tax expenditure analysis is used as a means of estimating the cost of such tax expenditures so that it can be assessed against alternative policy options. And following its genesis in the United States, a tax expenditure analysis was formally adopted by treasuries around the world, including in Australia, Canada, and Aotearoa, New Zealand. However, the tax expenditure analysis contributes materially to charities being misunderstood, undervalued, and overlooked. For example, a tax expenditure analysis provides only a rough estimate of cost. It is not possible to know how charities would behave if the tax privileges were removed. To the extent that removing the tax privileges might cause charities to reduce their services or even close altogether, government may have to make up the shortfall. But research indicates that charities carry out services more effectively and more efficiently than government, meaning that the cost to government of having to make up the shortfall may be greater than the amount that would have otherwise been spent on the tax privilege itself. More fundamentally, the tax expenditure analysis structurally ignores the externalities, the wider benefits provided by charities, which may be intangible and may be difficult to measure, but are nevertheless critically important. In fact, they arguably represent the very reason the tax privileges are in place in the first place. By focusing only on the cost, the tax expenditure analysis causes charities to be seen as a tax loophole or a fiscal cost, and therefore something to be reduced. Conceptualizing the tax privileges as a subsidy also leads to a mindset that decisions to award such a subsidy should be based on government perceptions as to what is worthwhile subsidizing out of public funds, rather than whether the thing itself is of public benefit. As such, charitable funds come to be seen as government funds, and charities come to be perceived and regulated as though they are merely underfunded service delivery arms of the state. Use of charities in this way has gained considerable traction in authoritarian countries like Russia and China, which have embarked on modernization strategies to engage civil society in partnership with government to improve the often dismal provision of social services. For example, the policy of the Communist Party of China is understood to be more third sector, less civil society. Under this policy, the charitable sector is viewed as purely service-oriented, with a role limited to either taking over social services from government or contracting with government to provide services. And following introduction of China's charity law in 2016, the social services charitable sector has grown very rapidly in China, encouraged by a significant increase in state investment and contributions. However, these successes have come at a cost. Democratic principles such as freedom of speech and freedom of association are significantly restricted. The charity law is used as a tool for suppression of not-for-profit advocacy. The advocacy activities of charities are tightly controlled, while service-providing charities are privileged through supportive policies such as access to funding, participation in policy decision-making, easier pathways to registration, less state intervention in their daily activities, preferential access to information, and prestige. Charities involved in social service contracting may therefore flourish even under a restrictive authoritarian regime and amid an otherwise shrinking space of civil society. But such a limited conception of charities comes at a cost. An independent civil society, of which charities are a significant part, is as critical to democracy as free and fair elections, an independent judiciary, and a free press. Exploiting charities for community service delivery while restricting their role in broader civil society undermines their independence. It draws charities into alignment with government and effectively turns them into instruments of the state. In this way, civil society may simply become an extension of the state's control over its citizens rather than a place for self-expression, pluralism, and mutual respect. Subsuming charities within the public service agenda blurs the boundary between charitable and government sectors. It also leads to a spread of bureaucratic risk aversion, damaging an important mechanism for change, renewal, and innovation in society. It risks turning charities into pale imitations of the government bureaucracy. I find it helpful to analyse these issues in terms of an underlying clash of paradigms, which appears to permeate this area of law. One paradigm sees the tax privileges for charities as a subsidy, but the other paradigm does not. It sees the tax privileges for charities as an investment in an overall system that allows people to manifest important liberal democratic values such as diversity, pluralism, social tolerance, and freedom of association in pursuit of public benefit, as determined objectively, rather than the conception of the public interest to which the government of the day seeks to give effect in its policies. Under this paradigm, the fact that some individual activities might not be selected for subsidisation in isolation by the government of the day is therefore tolerable. Some overbreadth is merely the price we pay for having a sector to act as a counterweight to government and for an overall system that contributes significantly to our social cohesion, well-being, and democracy. In other words, at the risk of oversimplification, one paradigm seeks to restrict charities, the other seeks to enable their work. The underlying clash of paradigms manifests itself in many different ways, including in how the definition of charitable purpose is interpreted. The interpretation of the definition of charitable purpose is important because it acts as the gateway to which charities can or cannot register under the Charities Act. There are insufficient guardrails in the legislation for how the definition is to be interpreted, and New Zealand is quite different to many comparable jurisdictions in this regard. And this lack of clarity has enabled the Department of Internal Affairs to interpret the definition of charitable purpose in New Zealand very subjectively and very narrowly. Interpreting the definition in this way leads to charities being seen as anachronistic, restricted to providing handouts rather than hand-ups, and therefore forced to wait until people have fallen off a cliff before being able to help them. This in turn perpetuates a deficits-based, capitalist, colonialist distinction between haves and have-nots that contributes to charities being seen as symptoms of the problem rather than integral to the solution. A wider interpretation of the definition of charitable purpose is strengths-based. It focuses on human flourishing rather than merely assuaging need. And it embraces the charitable sector as a key incubator of innovative solutions to intractable problems, capable of addressing prevention rather than merely cure, and devolving decision-making to those closest to the problem. Communities know best what communities need. In New Zealand, since the Charities Act was enacted in 2005, and particularly since the Charities Commission was controversially disestablished in 2012, there has been a slow-moving change of underlying paradigm from an enabling framework to one of ever-increasing restriction. Current interpretations are changing the nature of the charitable sector in New Zealand. Current interpretations are stifling charities' ability to innovate and to advocate for their charitable purposes, which undermines their critical role in our democracy. While 9/11 may have been the catalyst, use of the charities law framework to regulate charities has since taken on a life of its own, to the point that charities in New Zealand are increasingly being perceived and regulated as though they are merely underfunded service delivery arms of the state. These are uncertain times, and in times of uncertainty, people innately look for strong leadership. But in my view, what we really need are strong communities. Rather than a proliferation of government regulation focused on symptoms rather than causes, the better way to protect against increasing extremism is to bolster the bonds of community and democracy. Social cohesion is critical to preventing the development of harmful radicalizing ideologies, to strengthening resilience to the narratives of hate and division, and thus to preventing downstream violent extremism. It is often said that much like a virus, disinformation spreads through susceptible hosts. Democratic principles such as social tolerance, trust, and the rule of law act as a vaccine to the hateful and racist ideologies that are dedicated to destabilizing democratic principles and destroying democratic norms. In my view, one of the most important ways to bolster the bonds of community and democracy would be to remove unnecessary restrictions on charities' activities and reorient the charities law framework so that it boldly protects charities' independence, their important role in a liberal democracy, and their right to self-determine how best to further their stated charitable purposes as they see fit without undue government interference. As a small, unicameral, non-federal nation with a do-it-yourself mindset forged by geographical isolation, often described as the social laboratory of the world, New Zealand is well placed to be a vanguard in the reclamation of democracy. But if, on the other hand, countries such as New Zealand allow themselves to dismantle their own democracies through over-regulation of what should be an independent civil society, even inadvertently or by allowing regulatory creep, the terrorists and the autocrats will have won. The review of the Charities Act should have been an opportunity to address some of these issues. The charitable sector has been waiting for a proper first principles review of the Charities Act ever since the original Charities Bill was almost completely rewritten at Select Committee stage in 2004 and then rushed through under urgency without proper consultation. In the almost 2 decades since, no such review has been undertaken. Instead, the Charities Act has been subject to a series of piecemeal amendments that have similarly been rushed through under urgency without proper consultation, often against the strong objection of the charitable sector. Fast law does not make good law. The net result is a piece of legislation that is full of unintended consequences and much in need of a proper, independent, first principles, post-implementation review. The review of the Charities Act in 2018 that commenced in 2018 should have been an opportunity to address some of these issues. Sadly, although couched in glowing terms, the Charities Amendment Bill that was introduced into Parliament in September last year focuses on a much narrower range of issues than originally envisaged and has the potential to increase the regulatory powers of the Department of Internal Affairs without providing sufficient benefit to New Zealand's communities. The New Zealand government has recognised that social cohesion needs to be improved, but the connection between social cohesion and the legal framework for charities does not appear to have been made. Instead, the Charities Amendment Bill proposes further piecemeal reform to isolated aspects of an interconnected system and a seemingly inexorable march towards ever-increasing authoritarianism under the guise of promoting transparency and accountability. Even the Department of Internal Affairs' own regulatory impact statement speaks of inadequate consultation, inadequate problem definition, and a lack of evidence to support the proposals. Some of the proposals in the bill have not been consulted on at all, while almost every issue of concern for the charitable sector has been taken off the table. Submissions on the bill overwhelmingly call for the bill to be withdrawn and for the government to honour its 2017 manifesto commitment to carry out a proper first principles post-implementation review of the Charities Act, and one carried out independently of the Department of Internal Affairs. I doubt that anyone would disagree with the stated objective of the bill to make practical changes to support charities to continue their vital contribution to community wellbeing, while ensuring that that contribution is sufficiently transparent to interested parties and the public. But the problem is that the bill does not do that, as many submitters have pointed out. I understand that the Select Committee will make some changes to the bill. I've had an email from the Minister of the Finance's office who has said that the bill has been agreed and some changes have been made. We don't know yet what those changes will be. The Select Committee is due to report back next week. Charities did ask for an extension of the timeframe to make submissions by 1 month to 9 December. But, and they have heard oral submissions from, I understand, about 28 charities. They heard oral submissions for a total of 5 hours. At the same time as they've been considering the Charities Amendment Bill, they've also been considering the Accessibility for New Zealanders Bill and another bill about child support, plus several financial scrutiny hearings. So it gives the impression that the Select Committee really considered their role as one of merely rubber stamping the bill, which I hope is not the case, but we won't find out until next week. That's all I had.
Great, thank you very much. So I think I'll open the floor for discussion. If anyone has a question, please post them in the chat. I'm going to switch off the